Welcome to this week's lecture. This week we're going to be talking about the judicial branch, the third branch of the national government of the United States of America. The Constitution of the United States set up a government where three branches shared power and exercised checks and balances on each other. The judicial branch is the third branch that we will be talking about. We've already covered the legislative and the executive. The judicial branch is set up in the Constitution in Article 3. However, in that article, which happens to be the shortest article in the Constitution, in that article it only sets up the Supreme Court. No lower courts are set up. However, Congress is given the power to pass legislation to create whatever other courts would be necessary to the workings of the government. So we find out that in 1787 in Philadelphia, in the Constitutional Convention, that is when the Article 3 of the Constitution is written and the Supreme Court is created, the judicial branch is created. But it's the Judiciary Act of 1789 that creates all lower courts, all federal lower courts. And each state, each district actually now has its own federal court. When the Constitution was first written and ratified, and then the Judiciary Act of 1789 came out, each state had its own federal court. But as the country has grown, we have divided the country into districts. And we're going to talk a little bit more about that. There are two types of federal courts. There are special courts, and the range of cases that they hear are very narrow, and they're very specific to the powers of the court. And then there are constitutional courts. Constitutional courts consist of the U.S. Supreme Court, the Court of Appeals, and Federal District Court. When the courts were created, there was a question of jurisdiction. Jurisdiction, it simply means who has the right to hear the case. And to determine jurisdiction, two things are taken into account: the subject matter of the case and the parties involved in the case. So a federal court can deem that it has jurisdiction to hear a case because of the parties involved. For example, if two states are suing each other in court, then it is the federal court that hears that has jurisdiction. Or it may have to do with the subject matter of the case, where federal civil rights violated. Types of jurisdiction, there's actually 4 different types of jurisdiction. There's original jurisdiction, and that means that this is the first court to be able to hear the case. Original jurisdiction is usually going to be your lowest level courts. Then you have the appellate court, which hears cases that have already been heard and decided in the original jurisdiction court, but the person who lost that case wants a second chance, a second hearing. Now, in the criminal justice system, only the defendant can appeal to the appellate court. So if somebody is found guilty of a crime, then they and their lawyer can appeal to the appellate court. However, if the prosecution fails to prove that beyond a reasonable doubt that that the defendant is guilty, then that's it. That was their one shot. They cannot appeal that decision. You have exclusive jurisdiction, and that means that only that court can hear that case. And we're going to look at a couple of those examples a little bit later on. And you have concurrent jurisdiction, which means the case can be heard in both federal and state courts. An example of that would be a kidnapping case where the person was carried across state lines. If the kidnapping occurs through multiple states, then not only has the original state's kidnapping laws been violated, but also the federal kidnapping laws will have been violated. The levels of the court: the highest court is the U.S. Supreme Court, in the middle is the Court of Appeals, and the lowest is the Federal District Court. And actually, in your textbook, there is a diagram that shows you the hierarchy of the courts. And it's very similar to this diagram right here, simply with a little arrow in between each, and the arrow points up. So the lowest, then it goes to the middle, then it goes to the highest. The district courts, then the Court of Appeals, then the Supreme Court. inferior courts, which are courts below the U.S. Supreme Court. You have several different types. You have the federal district courts, and right now we have 91 of those, and these are the federal trial courts. So if you break a federal law, or if there is a lawsuit that has the federal government has the jurisdiction on it, then it will go to one of these district courts. It will go to the district court of which the parties are a member. This is where about 80% of the federal cases are heard. The Court of Appeals, as I've said, was already created by Congress. It was actually created in 1891. It wasn't part of the original Judiciary Act of 1789. It wasn't until 1891 that there was the Court of Appeals, and this was done to alleviate or relieve the U.S. Supreme Court of some of the caseload. Up until then, every single case that was appealed from the district court went straight to the Supreme Court. And so the Court of Appeals is kind of that middle ground, that middleman, to help alleviate some of the cases that were going to the Supreme Court because they were getting overwhelmed. There's a total of 12 appellate courts, and they can only hear cases that are being appealed. There are two other types of inferior courts. There's the Court of International Trade and the Court of Appeals for the Federal Circuit. The Court of International Trade would be one of those special courts that we spoke of earlier that can only hear cases that deal with international trade. So let's talk about the Supreme Court. First of all, the Supreme Court reviews cases to see if a law or an act is constitutional. This is called judicial review, and this is established in Marbury versus Madison. And we have talked extensively about Marbury versus Madison in U.S. history class. We will review the case in just a little bit later in this lecture. But the idea or the power of judicial review comes about or is first articulated in Marbury versus Madison. And it's simply the idea that the courts can declare a law or an act of any of the branches of the federal government as unconstitutional. Okay, so the U.S. Supreme Court, their session begins the first Monday in October. They convene the first Monday in October. They hold session for about 9 months, and during that 9 months, they hear cases from Monday through Thursday. On Fridays, they tend to discuss the cases that they've heard that week. And Mondays are a decision day. Now, that doesn't mean you're going to get a decision every Monday, but it does mean that when decisions are made public, they are made public on Mondays. So, jurisdiction. The U.S. Supreme Court can have original or exclusive jurisdiction over certain cases. There are certain cases that can go directly to the Supreme Court. However, that is a very rare occurrence. Appellate jurisdiction is what they exercise the most. Most of the time, they are going to hear the cases that have been tried in the district courts and in the appellate courts, and then another appeal has occurred. There are 3 different types of opinions that the Supreme Court can give. There is the majority opinion, which means the majority of the justices agree with this opinion. This is actually the decision of the court, and one justice will write the opinion, but all those that agree will sign on to it. Then there is a concurring opinion. This is written by a justice who agrees with the opinion, but has a different reasoning than what was in the majority opinion. So if 5 of the 9 justices agree on a decision, maybe they say that New Jersey was in the wrong in a commerce case against New York, and maybe 4 of the 5 judges that say that New Jersey was in the wrong, maybe 4 of the 5 say that New Jersey knowingly committed the act and tried to deceive New York in some way, and that violated law XYZ. But maybe the 5th justice While he agreed that New Jersey was in the wrong, maybe he didn't think it was done knowingly, or maybe it was a different law. Maybe it was law CDE that he felt was violated. So he agrees that New Jersey's in the wrong, and he's going to vote with the other 4 justices to say that, to be part, and he'll be part of the majority. But he may write his own opinion and explain his reasonings for why he sided with the majority, because they may be different from the majority opinion. And then you have the dissenting opinion. The dissenting opinion is the opinion of those justices that disagreed with the decision of the court, and they will give their reasons why. We've talked before about how Supreme Court justices get their role. They are appointed by the president, and they have to be approved by the U.S. Senate. So the president nominates a Supreme Court justice. There are hearings held within the Senate. The Senate votes on the Supreme Court justice, and that is how they get appointed to the Supreme Court. We currently have 9 Supreme Court justices. That's all we can have right now. That more legislation would have to be passed to increase or decrease that number of justices. Their term of office is for life or until they choose to retire. Once they are appointed as a justice, they cannot be removed from that position unless they commit an illegal act and they are impeached. The only other way for them to leave the office is to retire or to pass away. The first Chief Justice was John Jay. The current Chief Justice right now is Alito, I believe. No, I'm sorry, Roberts, John Roberts. John Roberts is our current Chief Justice. First African-American Supreme Court Justice was Thurgood Marshall, and this is him right here, Thurgood Marshall. He was the first African-American Supreme Court Justice. The first female was Sandra Day O'Connor, and that would be her picture at the bottom. The current Chief Justice, as I said, is John Roberts. Okay, special courts. These are courts that have a very narrow range of cases. They have to have specific content. They have specific power over this particular group of cases. And it can be, the examples of these are like federal claims court. This would be people who are suing the actual United States. So maybe they feel that a policy or something that the United States did has injured them in some way. Then they will sue the United States of America. So these cases would be Bishop versus the United States of America. You have the Court of the District of Columbia. And since the District of Columbia is not a state, it doesn't have its own court system. It's actually governed by the federal government. And so the Court of the District of Columbia is the court system that would hear criminal and civil cases in the District of Columbia. The Court of Military Appeals, that is going to deal only with military cases that have been courts-martialed and then are appealed. The U.S. Tax Court, this is only going to deal with somebody who has a tax case. Territorial courts, because territories are not states, they don't have their own court system, so the territorial courts take that place. And the Court of Veterans Appeals, which is going to deal with any cases that deal with veterans of the U.S. Armed Services. Now, Supreme Court cases that affect civil rights and liberties. We're going to mention a few of these for right now. Later on, I'm going to get a little bit farther into a couple of these cases. Freedom of religion is actually found in the First and the 14th Amendment, prohibits the establishment of a state religion. It says Congress shall make no law establishing or prohibiting. So not only can the federal government not establish a religion for the nation, but it cannot prohibit a religion in the nation. The free exercise clause is also found in the First and 14th Amendment, and it guarantees that you can believe what you want. There does have some limitations. You cannot harm others in your worship practices. So you can't believe in a religion where you are required to do human sacrifice. You can't exercise that. You can believe in it, but you can't exercise the human sacrifice. There are protections. Even if your religion is unprotected or is unpopular, even if your religion is unpopular, the government will protect your right to worship that way. So some cases that deal with some of this, Zorak versus Clausen in 1952. And this ruled that schools must release students for religious studies as long as the studies do not take place on school property. This would be this would relate to students who maybe are Jewish and they need to go to Hebrew school or have some sort of religious ceremony. And there could be other examples, but that's the one that comes to mind right now. Engel versus Vitale in 1962, Prayers in the Bible. This is the one that outlawed mandatory praying and Bible reading in schools. So when you hear people talking about prayer and Bible reading being taken out of the schools, it's Engel versus Vitale, 1962. Westside Community Schools versus Mergens in 1990. And this says that there's equal access. There's an equal access clause that says that students can have religious groups on public school campuses if non-academic clubs exist. So if your school if a public school has a 4-H club and a French club, well, a French club would probably be considered an academic one, but maybe a chess club, then you can have a Bible study there as well. Edwards versus Aguilar, 1987, deals with evolution. And here the court ruled that the teaching of evolution in public schools could not be forbidden and the teaching of creation could not be made mandatory. Couple more freedom of religion cases. There's Lynch versus Donnelly, 1984, deals with seasonal displays or holiday displays. It says that seasonal displays on public property like nativities are okay as long as they're part of a multi-religious or non-religious display. So if you have a nativity scene and Santa and Rudolph, that's okay. You can't just, on public ground, you can't just have a nativity scene, but you can have a nativity scene and other religions like a menorah for Hanukkah or Santa Claus or something like that. Marsh versus Chambers in 1983, the court ruled that chaplains in state legislatures and U.S. Congress are okay since it's tradition and the members are adults who are not susceptible to peer pressure. So that's why we can still have chaplains in the U.S. Congress and the state legislatures. Bob Jones University versus the U.S. in 1983 deals with tax exemptions. And there the court ruled that religious institutions could not keep their tax-exempt status if they practice discrimination. Now, that's a very general definition of that case. It doesn't mean that religious institutions have to hire people who are going to actively work against their religious beliefs, but they can't practice like racial discrimination or sexual discrimination. Lemon versus Kurtzman in 1971. This is where the court establishes the Lemon test, which says that federal aid for which stated that federal aid to a parochial school has to be for secular reasons, not to inhibit or enhance religion. So parochial schools or religious schools can get federal aid, but that federal aid has to specifically go towards things that don't enhance religion or inhibit religion. So it could go to the lunch program, that kind of thing. Freedom of speech and press are also in both the First and 14th Amendment. Free speech and free press are protected. There are limitations, however. The court has ruled in various areas that limitations can be placed on free speech and press. For example, you can't yell fire in a crowded theater unless there really is a fire, because if you create a stampede and somebody gets hurt, you're then liable for it. You cannot commit slander or libel which is defaming someone's reputation, basically saying something that's not true about them, either in print or in word. So some of the cases that deal with this: Miller versus California in 1973 deals with obscenity. And the court rules that contemporary community standards would be used in deciding what would be obscene. So as society changes, the definition of obscene changes. Neer versus Minnesota in 1931 says that the court said that prior restraint cannot be used unless the nation's security may be threatened. So you can't stop a press organization from printing a story unless it is dangerous for national security. Brasenberg versus Hayes in 1972, the court said that it was up to Congress and the states to decide if reporters should be made to reveal their sources. And the Tatel Film Corporation versus Cusack in 1968, the court ruled that motion pictures get freedom of the press, but are subject to obscenity rulings. So they can put forth whatever message they want, but they do have to adhere to whatever the contemporary community standards are for obscenity. Several more cases: Wilkinson versus Jones, 1987. This is where the court ruled that the radio and television are subject to regulation because the public airwaves are used to broadcast these things. Tinker versus Des Moines School District in 1969 is where the court said, and actually it's ruled both ways regarding symbolic speech, depending on the circumstances. In this particular case, they said it's okay to wear armbands in protest of the war because it doesn't cause a disruption to class. However, in other cases, when a disruption to class has been caused, they say that the school can restrict freedom of speech or expression by what you wear. 44 Liquor Mart Inc. versus Rhode Island in 1996. Here the court ruled that commercial speech is protected by the First and 14th Amendments, but false advertisement is still forbidden. Freedom of expression and national security. There's got to be a balance there. People have to be able to be free to express themselves and have freedom of speech, but you also have to protect national security. So the court has dealt with some cases that deal with that. Here's some things that they deal with or that they take into consideration. First of all, any of these acts that are listed here, any of the 4 acts that are listed here are punishable acts because they threaten the national security. However, it does limit freedom of expression. So these are 4 things that limit the freedom of expression, but are punishable acts because they also harm national security. The first one is espionage, which is spying on the U.S. for another country. The second is sabotage, which is trying to ruin, destroy, or break something that belongs to the U.S. The third is treason. This is the only crime mentioned in the Constitution. It involves a U.S. citizen waging war against the U.S., and there has to be at least 2 eyewitnesses to convict somebody of treason. That is why treason is very rarely charged. It's usually espionage that is charged. Espionage is much easier to prove. You don't have to have 2 eyewitnesses. And sedition. This involves speaking or writing things against the U.S. Now, this one has some limits on it. You can write an article saying that you think that the U.S. is not handling something well, and it's not going to be punishable for sedition. But especially during wartime, when what you write can be very inflammatory and cause a threat to national security, then that can be punishable by law. We've had the Alien and Sedition Acts in 1798. John Adams put those forth. They were repealed. They were very unpopular. They were repealed, and they were probably unconstitutional because we weren't in war. It wasn't wartime. Seditious acts during wartime. You had Schneck versus the U.S. in 1919. Has to do with the Espionage Act of 1917. That act was issued because we got involved in World War I, and it made it a crime to interfere with the draft. The clear and present danger rule came into this case. Schneck had urged men to resist the draft, violating the Espionage Act. The court upheld his conviction, saying that words can be outlawed if they pose a danger to security. And then there's a few other cases here. For sake of time, I'm not going to go through all the cases, but I do encourage you to pull up the PowerPoint on your own and make sure that you are taking a look at some of these cases. Freedom of assembly and petition is another civil rights issue, and there are several cases that have dealt with that. I encourage you to take a look at those. I'm just going to read the names right now. Grained versus City of Rockford, 1972. Cox versus Louisiana in 1965. Forsyth County versus Nationalist Movement in 1992. All right, so we're going to talk about due process right now. There are two different types of due process. There's procedural due process, and this says that the government must act fairly and abide by the rules. In Roshan versus California in 1952, this was a case where it said that police cannot use cruel and unusual punishment to obtain evidence. Roshan was actually forced to have his stomach pumped, and the court ruled that this was cruel and unusual way to obtain evidence. Apparently, he had swallowed some of the evidence, or the police believed he had swallowed some of the evidence, and they had his stomach pumped, and the court said, no, you can't do that. That's inadmissible. Then you have substantive due process. The way that the government acts and its laws must be fair. That's what substantive due process means. So procedural means they have to abide by the rules. They have to act fairly and abide by the rules. Substantive means that they have to be fair in what they're doing. And one of the cases that dealt with this is Pierce versus the Society of Sisters in 1925. The court ruled that the states could not force children to attend public schools. They can have mandatory education laws, but they cannot force that education to come from the public schools. It's why you can go to a private school today. Virginia has mandatory education laws. You have to get an education, but you can choose to be homeschooled, go to a private school, or go to a public school. Then you have cases that deal with police power relating to due process. Police power is the power of the state to protect public health, safety, and welfare. Some of what's going on right now with the coronavirus restrictions fall under this police power because it is trying to protect public health, safety, and welfare. An example of this, of a case like this, would be Schmerber versus California, 1966, where the court said it's okay for a policeman to order blood drawn from a drunk suspect's arm because acceptable medical practices were used and the evidence could have disappeared before a search warrant could be obtained. So this is why police can take somebody that they suspect of drunk driving to the hospital and have blood drawn and a blood alcohol test done. Because over time that blood alcohol dissipates and they could lose that evidence. And the drawing of the blood, as long as it's done by medical personnel, it's being done in a medically acceptable practice. The right to privacy, the definition to this is the right to be free from government intrusion into your private life. And a couple of cases that have to do with that are Griswold versus Connecticut in 1965, which says the government can't prohibit birth control counseling, and Roe versus Wade in 1973, which is the famous case where abortion is made legal. Okay, so we need to talk about the basic rights of the accused. If you wind up being accused of a crime and you are going to be put on trial, you need to know what your basic rights are. The first one is the writ of habeas corpus. This says that the accused must be told why you're being held prisoner. They cannot just hold you and not tell you what you're being charged with. The second one is bills of attainder. These involve convicting a criminal without a trial, and they're illegal. We cannot do that. You cannot be convicted without a trial. Now, you can plead guilty, but that would be your choice. If you plead not guilty, we have to give you a trial before you can be convicted. The third thing that's prohibited is ex post facto laws. This means that you can make a law retroactive, which means that the law was made today, but anybody who broke it yesterday is still in trouble. You can't do that in the United States. Ex post facto laws are prohibited by the Constitution. Double jeopardy. Double jeopardy is a term you need to know. Double jeopardy means that you cannot be tried for the same crime. Now, you can be tried for the same crime if it's in two different courts. So go back to that example I gave you of a kidnapping that takes the victim across state lines. That is violation of both a state law and a federal law. So the state can try you for kidnapping that person, and the federal government can try you for kidnapping that person. In a case like that, it's not considered double jeopardy. However, if you commit a robbery in the state of Virginia and you are tried for that robbery and you are acquitted, the prosecution cannot try you for that crime again. Even if later on they find definitive evidence that you did it, they still cannot try you for it again. And as long as you didn't break a federal law, the federal government can't try you for it. All right, jury trial or bench trial. These are two different types of trials that you can have. A jury trial means that you want a jury of your peers, 6 to 12 people, to decide whether you did or did not commit the crime. And they have to decide beyond a reasonable doubt that you did commit the crime. If they cannot say beyond a reasonable doubt that you did commit it, then they have to acquit you. A bench trial means that you've waived your right to the jury and you just want the judge to hear your case. And you can choose to do that. There have been several Supreme Court rulings that deal with the rights of the accused. Matt versus Ohio, 1961, says that evidence can't be obtained illegally. You have to have a search warrant that says what the police are searching for. Gideon versus Wainwright in 1963, the court said that anyone accused of a crime is entitled to a public defender. And then Miranda versus Arizona in 1966, the court ruled that anyone accused of a crime must be informed of their rights. This is where we get the Miranda warning, okay? So you've heard it a million times before. Anytime you've watched a show that had somebody being arrested, you've heard some version of it. It says you have the right to remain silent. If you give up that right, anything you say can and will be used against you in a court of law. You have the right to an attorney. So that came from Gideon versus Wainwright. You have the right to an attorney. If you cannot afford one will be provided for you. That's the public defender. Do you understand these rights as I have read them to you? Okay. That's where we get the Miranda warning. That's why we call it the Miranda warning, as it comes from the case Miranda versus Arizona, and it's listing for the accused what their rights are. Punishment for the accused. The Eighth Amendment protects against the use of cruel or unusual punishment or having to pay excessive fines or bail. And these are several court cases that are going to have dealt with punishment, whether or not somebody can have bail. And again, in the interest of time, I'm going to have you just go back and read the summaries of those. You see that Georgia is involved several times in the 70s with some of these cases. But these cases are going to deal with the death penalty. They're going to deal with bail. They're going to deal with several other issues. Okay, so what are civil rights? We hear a lot about civil rights and people's civil rights being violated, but what are these civil rights? First of all, they're guaranteed governmental protection of individual rights for all people. Okay? So where does segregation come in? Well, de jure segregation means segregation by law or custom. So this would have been what would have happened with the Jim Crow laws in the South. The whites-only restaurants, the whites-only hospitals, those kinds of things. De facto segregation is segregation by fact or housing patterns. People of like cultures and beliefs tend to settle together. So we still have segregation today, but it's de facto segregation. If you tend to notice that people in a neighborhood tend to have a lot in common culturally, and they just tend to do that. Nobody is saying this culture has to live here and this culture has to live there. It just kind of happens. It's the old saying, birds of a feather flock together. So that's de facto segregation. De facto segregation is okay by law. De jure segregation is not. Some cases that deal with segregation, you have Plessy versus Ferguson in 1896. And this actually upheld the segregation laws in the South, the Jim Crow laws. Then you have Brown versus the Board of Education of Topeka in 1954. And this decision reverses Plessy versus Ferguson's decision. It says that separate is, Plessy versus Ferguson said separate but equal was okay. So he said that races could be segregated into separate places as long as each of those places was equal. Now, they never were equal, but according to Plessy versus Ferguson, according to the court in that case, they could be made to be separate as long as everything was equal. Brown versus the Board of Education of Topeka in 1954 says separate but equal isn't possible and it's not legal. Then Alexander versus Holmes County Board of Education in 1969. That is the one where forced integration of schools began because the court said there had been enough time since 1954 for schools to be integrated, and anybody who hadn't integrated their schools at that point was in violation and had to get them integrated. Okay, discrimination is another thing we hear about with civil rights. The Civil Rights Act of 1964-1968 guaranteed rights to minorities and women that they had previously been denied. Affirmative action was a plan that was put in place to guarantee the quotas of minorities be hired. So it said that, there's this much percentage of this culture. So there's, 49% of the population are women. So 49% of your workforce should be women. It was that kind of thing. Affirmative action is what that does. Reverse discrimination is the process where majorities are actually overlooked for jobs or grants or things like that in favor of a minority. And we've actually seen, with affirmative action, we've actually seen reverse discrimination happen. Some cases that deal with that are Regents of the University of California versus Baker in 1978 and United Steelworkers versus Weber in 1979. Okay. Let's take a break, and when we come back, I will finish up. Welcome back. Okay, we're on to the second PowerPoint, and in this one, there's going to be some repeat of information that we've already covered, so I will go probably skip through that. This one I want to use to talk about the cases, some really important cases. I will review a couple of things, like the structure of the federal courts, and I'm just doing that because this is a different graphic. You may be able to see it better, and it may make more sense to you. So you have the federal courts and other entities outside of the judicial branch. So this would be like your military courts, courts of veterans appeals, the tax court, the federal administrative agencies and boards. So these would be what we would call your special courts. You have your trial courts, the U.S. district courts, the appeals court, and then the Supreme Court. Okay, we've already talked about the structure of the court. This is just another graphic that shows you how cases can get to the Supreme Court. And I hope you can see this. If you can't, please be sure to pull this PowerPoint up. This is kind of very light, and so I hope it's showing up for you. But if it's not, please make sure you pull the PowerPoint up and can see it. You have the U.S. district courts, and then cases from there can be sent to the Court of Appeals. And from the Court of Appeals, they can go to the U.S. Supreme Court. But there's another way to get to the Supreme Court, and that would be through state cases. And they would start out in the state district court. So in Virginia, it would start out in the Virginia District Court. And then it could go to the Virginia State Court of Appeals. Then it would go to the Virginia State Supreme Court. And then it could be appealed to the U.S. Supreme Court in certain cases. This is a graphic that shows you the different district courts. There are actually now 94 district courts. There's 12 appeals courts. So the black circles with the numbers in them are where the appeals courts are located. The 12th one is in D.C., and D.C. is so small you can't put the circle in there. Appellate courts have a 3-judge panel. and they can only review cases that were decided by the district courts. District courts, as we said, there's like 94 district courts. Okay. We've already talked about jurisdiction, so we're going to move on from there. I do want to talk about the precedents that the Supreme Court sets that lower courts must follow, and there's steps to getting a hearing in the court. And the first is that you grant certiorari, which is getting the case on the docket. The case has to be scheduled to be heard by the court. Briefs are then accepted from both sides. So both sides submit a brief, which is just a brief summary of the case, of their side of the case, to the judge. Oral arguments, or in this case to the Supreme Court justices. Oral arguments are then held on the date that is selected, on the day that the case has been put on the docket. At the time this PowerPoint was made, the Solicitor General of the United States was Donald Verrilli, and he would have made any arguments for the United States if the U.S. was named as one of the parties in the case. Judges will then conference, usually on a Friday, and a decision is issued. Opinion would be read on a Monday. Okay, so let's talk about who the judges are, who they were appointed by, and that kind of thing. Okay, so we've talked about how judges get on the bench. First of all, there are no qualifications in the Constitution for Supreme Court justices. You do not have to be a lawyer. You do not have to be a certain age. There are absolutely no qualifications listed in the Constitution. Now, that doesn't mean that we don't care about qualifications, but there are none listed in the Constitution. Presidents will almost always appoint ideological allies. And what that means is if the president tends to be a little more liberal, then he's going to appoint judges that tend to be a little more liberal. If he's a little more conservative, he's going to appoint judges that are a little more conservative. And the lower court, senators from these states will recommend names to the president. There's no way the president can have his eye on all 90-some district courts plus the 12 appellate courts for all the positions that are in there. If you notice on one of the slides before, it said there's over 600 judges sitting on the district courts. So there's no way the president can know every person and their background. So senators from that state will oftentimes recommend judges from their state for the lower federal courts. The president will then look at those names, and most of the time he will select somebody from those names to fill that seat. It's called senatorial courtesy. And that also builds him some support when it comes time to put judges on the Supreme Court. It's become a very politicized process. Just this past year, Judge Kavanaugh was nominated and appointed to the Supreme Court, and there was a huge amount of press coverage over that, long hearings about that, and I'm sure most of you saw at least some of that. So you know that it has become very politicized. The Senate hearing is usually held for nominees. The Judiciary Committee will look at the nominees first, and they will recommend to the Senate whether or not this person should be confirmed. But a recent failure for confirmation was Robert Bork in 1987. Race and gender can be factors in whether or not a person is confirmed. For example, if it's a woman justice that is leaving, then they may want another woman to fill the person. Ideology is key, though. Are they a judicial activist, or are they for judicial restraint? So let's look at some of the appointees. President Reagan appointed Antonin Scalia and Anthony Kennedy. Kennedy is still on the Supreme Court. Antonin Scalia is not. Antonin Scalia actually died in the last 6 months of President Obama's presidency, and that is what allowed President Trump to appoint his very first Supreme Court justice. Clarence Thomas was appointed by H.W. Bush, George H.W. Bush, the Bush number one. And there was a huge hearing about him as well. President Clinton appointed Ruth Bader Ginsburg and Stephen Breyer. By the way, Clarence Thomas is still on the bench. Ginsburg and Breyer are still on the bench. So Kennedy, Thomas, Ginsburg, and Breyer are still on the bench. George W. Bush appointed our Chief Justice, John Roberts, and Samuel Alito. And they are both still on the bench. And President Obama appointed Justice Sonia Sotomayor and Justice Elena Kagan. And they are both still on the bench as well. And then, as many of you know, President Trump has appointed 2 members to the Supreme Court. The most recent is Kavanaugh, and I apologize, cannot remember the first gentleman's name right now. Okay, so we're going to talk about, this last one is the decision, the oral arguments for Planned Parenthood versus Ayato. I can't say it, I'm sorry. Ayat, but we're not going to listen to that right now. We're going to talk about Marbury versus Madison. Okay, so Marbury versus Madison is where judicial review is established. Let's review what had happened. 1800 election, Adams loses. Thomas Jefferson is coming in. The night, Adams, his last night in the presidency, he makes appointments to the judiciary. He's a Federalist. Jefferson is a Democratic Republican. The Democratic Republicans hold the legislature. Now they're going to hold the executive branch. So Adams wants to be sure that the Federalists have a good hold on the judiciary. And so he makes a bunch of midnight appointments to the judiciary. However, the appointments do not get delivered that night. And they're still on the desk of the Secretary of State, James Madison, when he comes in to take over the job the next day. William Marbury was one of the midnight judges that was supposed to be appointed to the bench, and he knew the appointment was supposed to be coming. So when it didn't arrive, Madison was supposed to officially present Marbury with his new position, and he didn't. So Marbury actually sued and appealed to the Supreme Court to get Madison to give him the position. The verdict, the Supreme Court refuses to grant Marbury his position. Now, it's not because they say he's not entitled to it. They say that a section of the Judiciary Act of 1789, which sets up the federal court system, was unconstitutional and was void. And that was where Marbury's position was coming from. So what's the lasting impact? Well, this is the first time the Supreme Court has overturned an act of Congress. It says that that portion of the law was unconstitutional, therefore it was not valid, it did not need to be followed. It's an example of checks and balances in action. It's the very first time that the judicial branch checks the power of the legislature and executive. And judicial review is established, which is the Supreme Court's ability to declare a law or act unconstitutional. Now let's talk about McCulloch versus Maryland. Again, this is another case from U.S. history, so you should be familiar with it, but let's review it. So let's look at federalism. Federalism is the coexistence of federal, state, and local powers. So what was going on? The Second Bank of the United States was created. Remember, Alexander Hamilton had come up with this national bank idea to help with coining money, paying debts, that kind of thing. But it had to be chartered every so many years. What's the Second Bank of the United States is created. It's chartered. Maryland tries to impede the operation of the Bank of the United States. There were people who did not like the idea of a national bank. Maryland didn't particularly care for the idea, and they wanted to try and keep the Bank of the United States from operating. So they imposed a tax on all notes of the bank, of banks not chartered in Maryland. So if you were a bank that was not a Maryland state bank, then you had a tax was imposed on all of your notes, all of the loans that you had given to people, all the money you were making from those. Well, obviously the Bank of the United States is not chartered in Maryland. And it was the only out-of-state bank in Maryland because you couldn't operate in Maryland unless you were a Maryland bank or a federal bank. So what's the fundamental issue? Fundamental issues: did the Constitution grant Congress implied powers for implementing the Constitution's express powers? We've talked about implied and expressed powers. Express powers are those powers that are listed in the Constitution specifically. Specifically says Congress can do this, the president can do this. Implied powers are those powers that are necessary to carry out the expressed powers. So it may not be listed in the Constitution that Congress has the power to establish a national bank, but it is listed in the Constitution that Congress can coin money and can deal with financial issues for the United States. And Congress needs an avenue through which to carry out that responsibility. They said it was the U.S. Bank. The second issue is, can a state's action impede valid constitutional exercises of power by the federal government? So the second issue is, if it is constitutional for the federal government to do something, can the state try and keep it from doing it? The verdict. Well, on the first question, Justice Marshall argued that the necessary and proper clause of the Constitution implied that Congress could charter a national bank. In other words, he said there are implied powers in the Constitution. They're included in the necessary and proper clause because it says that Congress can do whatever is necessary and proper to carry out their duties. He said Congress was exercising its explicit power to regulate interstate commerce and coin and regulate money, and in order to do that, they needed the bank. The second question, Marshall said that the power to tax is the power to destroy, and that a state tax, if he allowed a state to tax a national bank, it violated the supremacy clause of the Constitution. The Constitution says, the supremacy clause of the Constitution says that the Constitution is the supreme law of the land. So, if a state was allowed to tax an act of the federal government that was constitutional, then in essence you were saying the state had more power than the Constitution, and they couldn't do that. So, the bank was legal. The Bank of the United States was legal. Maryland could not tax the bank. So this is some of the, this next slide is just showing you where in the Constitution some of these things were found. Article 1 of the Constitution, Article 6 of the Constitution is where the necessary and proper and the supremacy clauses are. All right, Gibbons versus Ogden. Again, another Supreme Court case that we studied in U.S. history. So hopefully this is just a review for you, but let's talk about it. This deals with steamboats and ferries. Okay, Ogden's steamboat monopoly. Under New York law that was adopted in 1798, Robert Livingston, who was actually a founding father, obtained a monopoly or the exclusive right for steamboat navigation in the state of New York. In other words, the state of New York said Robert Livingston is the only one who can operate steamboats in the state of New York. Any boats that competed with the monopoly were to be forfeited by the owner. So if you were operating a steamboat and you were not part of Robert Livingston's group, your boat was going to go to Robert Livingston. You gave up ownership of your boat. In 1815, after the deaths of Livingston and Fulton, Aaron Ogden obtained a right under the monopoly and began to run a steamboat between New Jersey and New York City. Okay, so Livingston passes, Fulton, who is the one who, if you'll remember, is the one who really made steamboat profitable. He passes away. Aaron Ogden is the one who gets this right, right to the monopoly. But he doesn't just stay in New York. He's running a steamboat between New Jersey and New York. So in 1818, Thomas Gibbons, one of Ogden's former partners, begins competing with him between Elizabethtown, New Jersey, and New York City. Okay, so under New York's monopoly law, Gibbons is violating the law. But he's going from New Jersey to New York City. Ogden sues Gibbons for violating his monopoly, and in 1820, New York's highest court found in Ogden's favor. So New York's Supreme Court said, absolutely, Gibbons is violating the monopoly we've given to Ogden, and that's not allowed. But Gibbons appeals to the Supreme Court. The Supreme Court unanimously, which is almost never happens, the Supreme Court unanimously concludes that the New York law granting the monopoly was invalid. Chief Justice John Marshall writes the court's opinion, and he says, commerce undoubtedly is traffic, but it is something more. Marshall concluded that commerce included all navigation that is in any manner connected with commerce. Now, that by itself did not void the monopoly law in New York. However, Marshall stated that the power of Congress to regulate commerce did not include commerce that was completely internal. Congress could not have anything to do with what New York said was commerce in New York. But it did not, and that did not extend to or affect other states. He said that the states had the power to regulate such completely internal commerce. However, the issue before the court concerned commerce between two states and therefore involved federal authority over commerce because the Constitution gives the federal government jurisdiction over interstate commerce and regulating it. So therefore, because it was between New Jersey and New York, two different states, the monopoly law did not apply. Okay, Plessy versus Ferguson and Brown versus the Board of Education. We're going to review these really quickly. Plessy versus Ferguson, as I said before, was the late 1880s, 1890s, late 1890s, and it said that separate but equal was okay. It upheld the Jim Crow laws, the segregation laws of the South. It said as long they can be kept separate as long as everything is equal. Brown versus Board of Education said separate is not equal, and therefore you cannot have segregation. And it's the one that started, made it illegal to have black schools and white schools, black restaurants, white restaurants, black hospitals, white hospitals, that kind of thing. Miranda versus Arizona, we have talked about this one as well. This is the one that says police have to inform you of your rights as soon as you're being arrested. So they have to say you have the right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. Do you understand your rights as I have read them? If a suspect says anything before they are Mirandized, it cannot be used against them. So here's some background on the information, on the case. Ernesto Miranda was arrested for kidnapping and rape. He was poor, he was uneducated, English was probably not his native language, and he was questioned for 2 to 3 hours intensively. Probably did not know he had any rights. Miranda was not told that he had the right to remain silent. So he wasn't told that he didn't have to say anything. He was not told that he had the right to an attorney. And after 3 hours, the police obtained a signed written confession from him. So what amendments apply to this case? Well, there's the Fifth Amendment, the right against protection against self-incrimination. There's the Sixth Amendment that gives you the right to an attorney. There's the 14th Amendment that gives you equal protection of the laws. So the ruling said that Miranda should have been told these rights. Therefore, police must explain these to anyone who is a suspect or arrested once they are in police custody. Police must ask, do you understand these rights? A suspect can decide at any time to exercise these rights, or they can voluntarily waive them. And this leads to the exclusionary rule, which says illegally obtained evidence cannot be used to convict a person of a crime. Statements made by any suspects that have not been informed of his or her Miranda rights have to be excluded from the trial. Statements made by any suspects who do not understand their Miranda warning have to be excluded from the trial. Okay, U.S. versus Nixon, we're not going to go over. This has to do with Watergate. Feel free to pull up the PowerPoint and take a look at it, but we're not going to go over it at the time. These were investigations into it, and that's the last one. There's one other PowerPoint I would like just to mention. We're not going to go through this one. It has all the same information, but it does have a couple of graphics on it that I thought were better than what we had seen before. This one on the federal court system, and it deals with just the constitutional courts, not the special courts. It actually does, it does have the special courts. So the military courts, if you're in the military and break a law or the Uniform Code of Military Justice, you will be court-martialed in a military court. If you appeal, it will go to the Court of Appeals for Armed Services. If you appeal from there, it will go to the Supreme Court. This says appeals from federal regulatory agencies. That has to do with like if you are cited or fined or something by the FDA or the USDA or something like that, and you want to appeal it, then your appeal goes up into this area. You're going to be in the appellate level. Territorial courts, district courts, courts of District of Columbia, U.S. Tax Court are all right here. So this is, you're not quite in the appellate area from the agencies yet. That's kind of your level with the district courts, in that if that court gives you a decision you don't like, then any of these can appeal to the U.S. Court of Appeals. If you are dealing with international trade, if you're suing the United States itself, or if you have veterans claims, these courts will hear those first, and any appeals from those will go to a special appeals court for the Federal Circuit. And then from this level, if anything is appealed, it all goes to the Supreme Court. I hope I explained that well enough. And then this helps you see where the appellate courts are. So if you have a federal court case here, and then and you're appealing to the appeals court, you're going to be the 9th appellate court. So hopefully that helps you see where those would be. And this is just a chart that gives you the number of judges, the number of courts, and how long their terms of appointment are. There's a few courts down here, the appeals for the Armed Forces, Tax Court, Federal Claims. They have a 15-year term, and then they would have to be reappointed or move on or something like that. And this is a picture of the Supreme Court justices. This is not up to date. This is not up to date. It does not have anybody that President Trump has put into place. And actually, John Paul Stevens has been off for a while. But that shows you what they look like. This is more up to date. Like I said, Stevens is not on there anymore. All right, and then that goes back to jurisdiction. I hope that this has helped you understand the judicial branch a little bit more. And I thank you for taking the time to listen. Please send me an email if you have any questions. Have a great rest of the day.